Hi, I'm David Lawrence. I'm the chief of the Policy and Advocacy Section at the United States Department of Justice and the Antitrust Division. And I'm delighted to be joined by Shaoul Sussman, who is a senior advisor to FTC Chair Lina Khan. Today we're going to be talking about a range of bills that are being debated in the United States Congress. As you'll see, there's a great deal of attention being paid on a bipartisan basis to potential competition law reforms, particularly as to digital markets.
One thing to note before we begin is that there is a lot of energy around some of these bills. None of them are certain to pass. It remains unclear what, if anything, will ultimately pass. And so you'll hear about the bills in some cases have overlapping coverages in areas of intersection. There are basically two types of competition bills progressing through Congress. First are tech-targeted bills that focus only on issues around tech. The second are more general antitrust reform bills, and Dave will begin by talking through the focused tech bills.
Thanks, Shaoul. So, I'll be focusing first on tech or digital platform focused bills, and I'm going to start with the bill that has the broadest bipartisan support so far in the United States Senate, and that's the American Innovation and Choice Online Act. You could think of this as a digital platform non-discrimination act. This was introduced by Senator Amy Klobuchar alongside Senator Chuck Grassley, along with 10 additional co-sponsors, 6 Republicans and 6 Democrats. And it's comparable in many respects to a bill in the United States House of Representatives. Okay, so substantively, this bill would set rules that protect competition on covered digital platforms, and we'll get in a moment to what covered means. This includes a variety of non-discrimination provisions, rules prohibiting platforms from engaging in self-preferencing, limiting the ability of users to compete with themselves on the platform, or discriminating the application of platform terms or service, and in all those cases in ways that would materially harm competition on the platform. The bill also, in addition to general non-discrimination provisions, has a number of specific prohibited forms of discriminatory conduct. There are actually 7 of them, such as biasing search results or using non-public data to compete in a discriminatory way, and there are several others. The bill, those are the provisions that set forth what's prohibited under the bill. It also establishes an affirmative defense under which a defendant could escape liability for what's otherwise prohibited conduct if it was necessary to prevent a violation of the law, to protect safety, user privacy, the security of the platform or of non-public data, or to maintain the core functionality of the covered platform. And so if there's a violation, the defense isn't applicable. The potential remedies include equitable relief, which is injunctive relief. So that's conduct prohibitions, rules of the road that could be set as a result, and also civil penalties of up to 15% of platform company revenues. So the coverage formula for this legislation is very important. As I mentioned earlier, it only applies to covered platforms. So the definition of a covered platform in the bill determines which companies it applies to and which it does not. It's designed to cover the most economically significant digital platforms that possess gatekeeper power, the power to control whether or how businesses reach consumers or business customers online. So the bill, according to its coverage definitions, covers online platforms that have at least 50 million US users or 100,000 business users, are owned or controlled by a person with net sales or market capitalization of greater than 550 billion, so these are big companies, and constitute a, quote, critical trading partner for any product or service offered on that platform. That's likely to be an important term in the application of the legislation. It also contains a framework by which the Federal Trade Commission or the Department of Justice, working together, can designate a company as covered by these provisions in advance, so that ahead of time companies know they'd be covered as opposed to having to wait until a lawsuit is filed for a violation. One thing I'd note about this non-discrimination bill's coverage framework is that it'll include more companies over time as those companies come to meet the criteria. So in this particular bill, it's flexibly applied as companies change over time. I'll turn now to a second piece of legislation also introduced on a bipartisan basis that shares a very similar coverage formula to the one I just mentioned for covered platforms. And this is the Senate Platform Competition and Opportunity Act. This bill, whereas the last legislation I mentioned covered non-discrimination for covered platforms, this relates to mergers and acquisitions. And it was also introduced in the Senate on a bipartisan basis. And it's a companion, again, to similar legislation in the House. Substantively, it would prohibit any acquisition by companies that operate a covered platform, unless the merging parties can prove, by clear and convincing evidence, that the acquisition is valued at less than $50 million, that the target does not compete with the covered platform's operator, or does not constitute a nascent or potential competitive threat, or that the acquisition would not enhance the covered platform operator's market power or its ability to maintain its market position as a critical trading partner platform. And it provides for enforcement by federal and state authorities, as well as a private right of action. It has a very similar coverage formula for covered platform, but unlike the non-discrimination legislation, the covered platform definition applies as the date of enactment of the legislation and then is static. So platforms that are covered on the day of enactment would be covered. If a company later grows into the coverage formula, that wouldn't matter. It still wouldn't be covered. So those are two companion bills that have been introduced in the Senate. I'll just briefly mention a couple other pieces of legislation that have been introduced in the House of Representatives so far that share a similar coverage formula, so that would apply, again, big tech focused to covered platforms. So one of them is called the Ending Platform Monopolies Act, and it would impose vertical structural separation on covered platforms. It basically would require covered platforms or prevent covered platforms from owning other businesses that operate on the covered platform, which would create a conflict of interest. Another bill that uses a similar coverage formula is, short, the Access Act is the acronym. That's an interoperability. It's a piece of interoperability legislation requiring covered platforms to permit interoperability from potential competitors or other businesses with the platforms themselves. There are just two other tech-focused bills I'll cover briefly. One of them relates specifically to app markets. It's called the Open App Markets Act, also introduced on a bipartisan basis in the Senate and the subject of a lot of discussion there. This bill would set rules to protect competition, app developers, and consumers within the app market. So think about the store for apps on your smartphone or other device. And it includes rules that prevent covered app stores from tying a third party's app to the covered app store, from imposing restrictions on the app developers' communications with app users, from using non-public business information derived from a third-party app for the purposes of then competing against that app, or from unreasonably preferencing the app. So it's an app store competition bill focused specifically not just on tech, but specifically on apps and the app market. And I'll just mention one final big tech-focused piece of legislation in the Senate. This is the Journalism Competition and Preservation Act. As you'd guess from the name, it's particularly focused on journalism. Introduced by Democratic Senator Amy Klobuchar, Republican Senator John Kennedy, and a number of others, the bill would create a 4-year safe harbor from antitrust laws for print or digital news companies and news broadcasters to collectively negotiate with dominant online news content distributors, such as the major platforms, one could imagine Google or Facebook or the like perhaps, regarding the terms on which the news company's content may be distributed by those online content distributors. So one final piece of digital market-focused legislation to watch. There's also, of course, a lot of general antitrust enforcement legislation that Shaoul will be talking.
That's right. So we're going to cover both general antitrust legislation proposals and also the recent executive order that covers competition. So the first piece of legislation is a piece that was introduced by Senator Amy Klobuchar and is co-sponsored by 9 additional Democrats in the Senate. And it's called the Competition and Antitrust Law Enforcement Reform Act. And it really focuses both on merger law and anti-competitive conduct. On mergers, the bill redefines the standard under Section 7 of the Clayton Act to forbid mergers that create appreciable risk of materially lessening competition, which would, under this bill, be a more aggressive standard than the current language, which is substantially lessen competition, where materially is defined as more than de minimis amount. The bill also defines several categories of mergers that pose a significant risk to competition, and they shift the legal burden to the merging parties to articulate or prove why the proposed merger is not going to increase the appreciable risk to competition or meet the standard under this bill. So the bill also focuses on specific categories here, so transactions that significantly increase market concentration, horizontal acquisition by dominant firms, with dominant firms defined as 50% market share or more, and then also acquisition of maverick competitors, acquisitions that might result in anti-competitive effects, and then also mega mergers, which are transactions that are valued at more than $5 billion under this bill, where the acquiring party has a certain asset or revenue threshold of more than $100 billion and market acquisition of more than $50 million. On conduct, the bill creates a new prohibition around exclusionary conduct, and defines it as conduct that materially disadvantages competitors or limits their opportunity to compete, and present a appreciable risk of harm to competition when a company has a market share of 50% or more, or otherwise has significant market power and engages in exclusionary conduct. So just comparing to the current standard today, 50% is on the lower end of the spectrum under existing case law in the United States, and the appreciable risk of competition is also a more lenient standard for plaintiffs in those types of cases. Civil penalty authorities would be added to the bill as well. The bill provides the agencies the power to seek large civil penalties for antitrust violations that are up to 15% of the company's U.S. revenue, and also increases resources for the agencies in the form of annual appropriations, both to the Department of Justice Antitrust Division and to the Federal Trade Commission. The second piece of general antitrust legislation we'll touch upon was introduced by Republican Senators Mike Lee and Chuck Grassley. It is called the Tougher Enforcement Against Monopolies Act, and it proposes a number of changes to existing antitrust law and precedent. So on merger side, it would codify a rebuttable presumption of illegality for mergers that result in a merged entity with a market share of more than 33% or greater than 5% if the controlling party is controlled by a foreign government. It would result in a merged entity that could meaningfully increase price or reduce output, innovation, or quality in the market. That's another presumption of illegality. It would also introduce a outright ban on horizontal mergers that result in market share greater than 66% of a relevant market, except to the extent that such transactions are necessary to prevent serious harm to the national economy. On the conduct side, the bill would deem anti-competitive under the Sherman or Clayton Act any conduct or transaction in which there is direct evidence that the conduct or transaction was undertaken with a clear intent to harm or prevent competition. Currently, under existing case law in the U.S., intent is an area of focus, but is not a necessary element in a claim. It would also codify the parameters of an in-market efficiencies defense under the Claim and Sherman Act, as well as effectively codifying a definition of the consumer welfare standard. And finally, the bill also introduces some reforms around funding and structure of antitrust enforcement on the federal level. And one of the key provisions is the elimination of the Federal Trade Commission and its incorporation into the Department of Justice Antitrust Division. On the administration front, President Biden in July signed an executive order to promote competition throughout the economy, and had two main aspects that are relevant to this overview. The first is the encouragement of various federal agencies to consider using their rulemaking authority to pass rules that will promote competition. And the second is adopting a whole of government approach towards antitrust enforcement and antitrust issues, where additional agencies outside the Department of Justice and the Federal Trade Commission will use their existing statutory authority to analyze the anti-competitive aspects of transactions they review or types of conducts they witness in various markets. So as you can tell, there is a slew of very activity in this field, both on the House and Senate for legislation, and also in the executive branch through the executive order.
Yeah.
And more to come, I assume.
Yeah, I agree. And what's so interesting about the executive order you conclude with, Shaoul, is not a law. The rest of what we discussed are laws that are under debate, but something that's already been issued by the president and instructs the various federal agencies how they should use the laws that are already on the books, which is what our agencies are certainly busy doing.